Hello, welcome again to the Constitution Study with Paul Engel. I am so glad you could join me. This should be an interesting episode today. I just finished writing an article about the Masterpiece Cakeshop case that was just decided by the Supreme Court of the United States. We'll be talking about that today. I hope you'll find it not only interesting, but I hope you'll see how I go about analyzing what I see in the news, so you can use that to help think more logically about what's going on. Before I get into that, though, I want to thank you for being here. If you are a first-time listener, welcome. Thank you very much. I don't know if you were pointed this way by somebody or if you just found this title interesting. Either way, I'm glad you're here. I hope you'll find this worth your time. I hope you'll find it educational. And I hope you'll subscribe. Go to Apple Podcasts. You can subscribe to the Constitution Study podcast. You can also go to the website, constitutionstudy.com, and get other episodes and other articles that I post about the Constitution Study. If you're returning, you know all that, and I'm glad you came back. I'm glad you were willing to listen. Again, I hope you'll find this in the same vein, where we're looking at what's going on in the news in this case from a constitutional point of view, looking at the actual words on paper, not just what some pundit is saying about it. In either case, I hope, again, you'll go to the Constitution Study. I'm asking you to sign up for my mailing list. If you do so, you'll get a copy of my essay, How the 16th and 17th Amendments destroyed the Republic. You get that for free for signing up to the mailing list. You can also support the Constitution Study. You'll see a link at the bottom of the page to my Patreon page, where you can support the work that I'm doing and hopefully allow me to do even more. So with that out of the way, let's talk about this decision in Masterpiece Cakeshop versus Colorado Civil Rights Commission. I intentionally did not write anything or post anything or blog about or podcast about this until I've had a chance to digest it. As expected, as soon as it comes out, there's a lot of rhetoric, there's a lot of hyperbole, there's just a lot of information coming at it from a lot of different directions, and I find it interesting that none of the blog posts that I wrote, none of the articles that I read actually had a link to the decision itself. I guess you were just supposed to take their word for what the decision actually said. So I did something which I guess is unique. I actually read the syllabus of the decision. I did not read the entire decision. I read the syllabus and I read some of the concurring opinions. But I find it important to go back, to weed through all the noise, to go back and find out what was actually written, what was actually said, to find out where the truth is. And not surprisingly, it's kind of somewhere in the middle. So some background, if you're not familiar, Jack Phillips is the owner and operator of Masterpiece Cakeshop in Colorado. In 2012, a same-sex couple came to Mr. Phillips to create a custom cake for their wedding. Now, at that time, neither Colorado nor United States recognized same-sex marriages. Mr. Phillips refused to make a custom cake for their wedding because he had religious objections to same-sex marriage. He did, however, offer to sell them anything else in his shop. Now, this is not unique. Mr. Phillips also refuses to bake cakes containing alcohol, with racist or homophobic messages, cakes criticizing God, or celebrating Halloween. So this is not a one-off event. This was his environment. The couple immediately filed charge with the Colorado Civil Rights Commission, pursuant to the Colorado's Anti-Discrimination Act, which prohibits discrimination based on sexual orientation in a place of business engaged in any sales to the public. The charge was eventually referred to an administrative law judge who found in favor of the couple, rejecting Mr. Phillips' claim that requiring him to create a custom cake against his will was a violation of both his free speech and free exercise rights protected under the First Amendment. This decision was upheld by the Colorado Civil Rights Commission and the Colorado Court of Appeals. This is how it ended up going to the Supreme Court. Now, once we sweep away all the rhetoric, I've heard everything from it's a narrow decision, it's a broad, far-reaching decision. You sweep all that away. You go down to what the court actually found. You read the syllabus, which is a bit of legalese, but not as hard as you might think. The court found several things. First, the court found that while laws in the Constitution do protect gay people in the access of their civil rights, objections to gay marriage are protected views and may be protected forms of expression. So yes, objections to gay marriage is protected speech. The Colorado law can protect gay persons from obtaining services and goods on the same terms as other members of the public. However, that must be applied in a manner that is neutral to religion. So yes, all people, including homosexuals, should have their civil rights protected, but so should those who object to same-sex marriage, whether it's a religious reason or not. The law cannot discriminate on religious grounds. Second, the Colorado Civil Rights Commission showed clear hostility to Mr. Phillips' religious liberty claims. The record shows clearly that during these formal hearings, some commissioners endorsed views that religious belief cannot legitimately be carried into the public square. You can believe anything you want, you just cannot do it in public, or you cannot do it as part of a business. They disparaged Mr. Phillips' faith as despicable. They characterized it as rhetoric and compared it to invocations of sincerely held religious beliefs as a defense for slavery or the Holocaust. None of the commissioners objected to this. Nobody complained about it. It wasn't disavowed in any court filings. This was the CRC's, the Civil Rights Commission's opinion, and was not objected to by anyone else. In addition, while this case was pending, the Civil Rights Commission had 3 other bakers that were charged under the same statute for not making cakes. In this case, cakes that demeaned homosexuals and same-sex marriage. And in each case, the commission said that the baker had acted lawfully. There was nothing wrong with refusing to do work for somebody who wanted something that they found offensive, apparently as long as that offensiveness is pro-homosexual, not against homosexuals, or pro-heterosexual traditional marriage. See, by treating Mr. Phillips' claims differently because they disagreed with him, the commissioner's point of view, they showed that it was impossible for him to get a fair and impartial hearing. Mr. Phillips deserved the same neutral and respectful consideration of his claims as the other bakers received. Now, third, the state entity, in this case the Civil Rights Commission, cannot determine what is speech and what to protect. Quoting from the ruling, the commission ruled against Phillips in part on the theory that any message on the requested cake would be attributed to the customer, not the baker. Yet the division did not address the point in any of the cases involving requests for cakes depicting anti-gay marriage symbolism. The division also considered that each bakery was willing to sell other products to the prospective customer, but the commission found Phillips' willingness to do the same irrelevant. In other words, the commission said, well, the 3 bakers that were refused anti-homosexual messages, well, they wouldn't be allowed to do that because that would be forcing them to contribute to speech, to expression that is discriminatory. But they denied Mr. Phillips the exact same ruling that he not be required to communicate, to express himself in a way that he finds objectionable. The commission also looked at the 3 bakers and said, well, so you offered to sell them anything that was already in the store, that makes it okay. But when they looked at Mr. Phillips, they wouldn't do the same thing. It was obvious viewpoint discrimination. It was obvious bias. In addition, the court found that the state has a duty not to enact laws or regulations based on a hostility to religion or religious viewpoints. Now, the court found that that's exactly not only what the Civil Rights Commission did, but I think if you look at most anti-discrimination laws, they are designed to be hostile to people of a religious viewpoint. Quoting again from the opinion, the government, consistent with the Constitution's guarantee of free exercise, cannot impose regulations that are hostile to religious beliefs or affect citizens and cannot act in a manner that passes judgment upon or presupposes the illegitimacy of religious beliefs and practices. The government doesn't get to decide what is a legitimate religious belief and what's not. And it can't impose laws or regulations that are hostile to them. So overall, the court found that the commission was neither tolerant nor respectful of Mr. Phillips' free exercise claims. And that's where people who say this is a limited ruling are correct. Yes, it was a widely held decision. It was 7-2. But the court focuses strictly on how the Civil Rights Commission treated the claims of Mr. Phillips, not the claims themselves. Right? So what did the Supreme Court not find? They did not find that Mr. Phillips was within his rights to refuse to create a custom cake that expressed an opinion that he personally disagrees with. That is not part of the ruling. In fact, quoting from the opinion, the state's interest could have been weighed against Phillips' sincere religious objections in a way consistent with the requisite religious neutrality that must be strictly observed. In other words, they could have done it. They just didn't. They didn't have to be hostile to Mr. Phillips' religious objections. The court did not find that using one's creative talents is a form of expression protected by the free speech and free press clauses of the First Amendment. The court did not find that a person cannot be compelled by the state to create an artistic work based on the creator's religious belief. While the court did reverse the decision of the Colorado Court of Appeals by a significant margin, it did so only on the narrowest of points, the hostility of the commission to show Mr. Phillips' religious belief due credit and honor. Now, as with most cases, not all the justices agree. Justices Thomas and Gorsuch, they agreed with the ruling, but they wanted to make their own point. There was something that the court didn't recognize or didn't include in the opinion that they wanted to get out, and that is, the court didn't deal with the question of whether being compelled to create a custom wedding cake is a violation of Mr. Phillips' free speech rights. This was the core of his claim. His primary claim was that being compelled by the state to make something was a violation of his free speech rights. However, what the court found was that the commission was hostile to his free exercise rights. Quoting from their concurring opinion, Thomas and Gorsuch say, the Colorado Court of Appeals was wrong to conclude that Phillips' conduct was not expressive because a reasonable observer would think he was merely complying with Colorado's public accommodations law. This argument would justify any law that compelled protected speech, and this court has never accepted it. So, and this is why people say, yes, it's very narrow. They didn't deal with the core of the question, the core problem. Can the state, can the government compel you to do something, to express yourself in a certain way, regardless of why you disagree with it? And I think that is probably the major, reading through the concurring opinion, that's their major complaint, is they did not deal with this very, very important issue. In fact, reading from the concurring opinion, the Court of Appeal did not address whether Colorado's law survives strict scrutiny, and I will not do so in the first instance. There is an obvious flaw, however, with one of the asserted justifications for Colorado's law. According to the individual respondents, Colorado can compel Phillips' speech to prevent him from, quote, denigrating the dignity of same-sex couples or asserting their inferiority, and subjecting them to humiliation, frustration, and embarrassment. These justifications are completely foreign to our free speech jurisprudence. In other words, the Court of Appeal said, listen, we can make you act a certain way because we don't want you to denigrate or make somebody feel inferior or feel embarrassed. But that's the entire purpose of the free speech clause, is that you cannot be compelled to say something that you disagree with, even if someone doesn't like it, even if it makes them feel bad, even if it frustrates them, humiliates them, even if they feel embarrassed, it doesn't matter. It's your speech. States cannot punish free speech because some groups find it offensive. In fact, let me quote from the concurring opinion. States cannot punish protected speech because some group finds it offensive, hurtful, stigmatic, unreasonable, or undignified. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. Boom. And the court sidestepped it. They missed it. They didn't want to deal with it. They missed that piece, which was the core of the actual argument. Now, being this is a 7-2 decision, not everybody agreed with the court. Justices Ginsburg and Sotomayor, well, they issued a dissent. They didn't agree with the court. They do not believe that the same-sex couple should lose this case. In their opinion, the Civil Rights Commission did not show hostility to Mr. Phillips' religious belief. Justice Ginsburg noted that while the three cases the commission's dismissed involved a specific request for language on the cake, but the couple's request did not. The justice opinion that Mr. Phillips' issue was with the couple's sexual orientation rather than participating in the wedding it belies the fact that Mr. Phillips offered to sell them any baked good in the store. His only objection was to making a custom cake for their wedding. And that's the important point. It was a custom cake. Regardless of the words he put on it or didn't put on it, he was making a custom creation for them. And the idea that, well, just because there wasn't language on it, that misconception of the facts of the case leads me them to disagree with the obvious difference between selling something regardless of the customer, which was offered, and the expression included in making custom creations. To take that opinion to its logical conclusions, could you not force, say, a seamstress who makes robes and flags to make a KKK robe and a Nazi flag, regardless of whether she found it offensive or not? Whether or not the creation involves language, it does involve expression. Therefore, it falls under the free exercise clause. Justice Ginsburg and Sotomayor go on to explain that while the court found the different treatment of the two groups, Mr. Phillips and the other three bakers, were the court said were based, quote, based on the government's own assessment of offensiveness. But they go on to say that the fact that Mr. Phillips declined to make the cake because he found it offensive, while the other bakers obviously made it because the language requested was obviously offensive. See, to me, rather than showing that the government was not determining whether something was offensive, they were demonstrating how the government actually was determining what was offensive by saying that, well, Mr. Phillips found that offensive, but what the other bakers were asking, well, that was obviously offensive. That's their opinion. That's not their role. They're not there to determine what is and is not offensive. The fact that neither justice seems to have a problem with government officials standing in judgment of others, using blatantly derisive, dare I say, offensive language to describe the motive of others, I do not see how they can't see the comparison of one's belief with two of the most racist and destructive ideologies in history as anything but discriminatory. Yet they do. So to wrap this up, I'm getting close on time. Here's where we sit. When you read the actual decision, it was a widely decided but narrow decision. It was 7-2, but it was narrowly decided that when any of these government organizations, when they are dealing with a complaint, they must appear to be religiously neutral. And that's actually, I word it that way specifically, because it doesn't say they have to act that way. It says they should, but let's face it, you can certainly shape your questions, shape your actions to appear religiously neutral. And as long as you aren't blatantly religiously bigoted, you could pass muster based on this court. They didn't deal with the free speech rights. They didn't deal with the underlying religious liberty right. They found a very narrow way to deal with this particular problem. And the other thing is, if you look at Justice Ginsburg and Sotomayor, their view of free speech, their view of how the government is supposed to treat citizens, the citizens they work for, to me, really is twisted from what was created by our founding fathers. They believe that the government, that when the government or government representatives are hostile, derogatory, demeaning to people of religious belief, then that's fine. But, and that the government really should be deciding what is and is not offensive. So I hope you found this interesting. I hope you saw that it's important sometimes to take some time to find all the facts, listen to different points of view, sift it down to what the words actually say, and then make your decision based on that. So I hope you enjoyed this. I hope you'll come back here. I look forward to seeing you again on the Constitution Study.